Today we will look at the fascinating final hearing at the Bainbridge Island Municipal Court, in the protection order hearing brought by John Doers against Houston Wade. There Judge Sara McCulloch dismissed the temporary protection order against Wade, finding that the crux of the case was whether defamation against Doers had occurred. Judge McCulloch found that while defamation against Doers may have occurred, not all of his claims of defamation by Wade were actually defamatory. In fact, Doers admitted under oath that some of those claims made about him were, as it turns out, true. Our video will consist of 4 parts. In the first part we look at the claims of defamation made by Doers and examine how the court record judged each claim. The court found that the key to Doers' case was defamation, but was not convinced that defamation had occurred by the evidence he presented. We will make own analysis of each claim. In the second part, we will examine the ruling and reasoning of Judge Sara McCulloch, and highlight the incredibly stark contrast with her ruling in a similar hearing, when she issued a permanent protection order against Richard Rynearson, on behalf of Clarence Moriwaki and Moriwaki v. Rynearson. In the third part, we will discuss some theories as to why Judge McCulloch's ruling was so diametrically opposed to her own ruling in the Rynearson case months prior. In the fourth and final part, we will discuss the upcoming Bill Nelson v. Houston Wade final protection hearing, given these 2 theories, and discuss what we expect will happen in that hearing on the 3rd of December. In the hearing, Doers distances himself from the defamation argument, and attempts to zero in on the intent behind Houston Wade's speech. He suggests that intent, rather than the truth or falsity of statements, is where the legal analysis should be focused.
The proof really would lie in Mr. Doers in trying to prove that this falls within the defamation category.
I know that Mr. Wade hopes that the case will only be about defamation. Your Honor's line of questioning seems to focus on the defamatory quality of the posts.
That's correct.
And the overwhelming case law says that defamation is a completely separate question from harassment and cyberstalking under the Washington statutes as well as the federal cyberstalking statute.
Well, before you go into that, doesn't RCW 1014-020 indicate that the course of conduct does not include constitutionally protected free speech?
It does. Defamatory language is one of the many kinds of unprotected non-free speech. There are several kinds. The statutes in Washington for cyberstalking and harassment deal with another kind, specifically under the Giving Doctrine. Defamation would be a whole other conversation.
In several instances, Doers attempts to draw a sharp line, and argues speech that is harassing, or defamatory, can be restrained. After distancing himself from a defamation argument, Doers then essentially makes the same argument that Clarence Moriwaki made to the court earlier. While Moriwaki's legal argument might be summarized as, "Speech I don't like should be punished," Doers' argument is presented as, "Speech that is a bad intent and is not socially valuable should be punished." While Moriwaki would present the speech to be censored as speech he personally did not like or agree with, Doers' argument shifts the decision maker to a judge, who he argues should make the decision on the value of speech. The arguments are essentially the same, arguing that speech can be censored if somebody doesn't like or value that speech. Doers relies on the Attorney General's response in the federal suit, Rynearson v. Ferguson, to argue speech that is carried out, in other words speech that is spoken, constitutes action, and that speech with the intent to harass rather than to provide subjectively valuable social commentary is therefore criminal conduct. Judge McCulloch rightfully dismisses the idea that intent in speech, or the act of actually speaking the speech, transforms speech itself into conduct. She correctly identifies the crux of the issue at hand as being whether or not claims from Wade were, in fact, defamatory. While Doers argues that protection orders for cyberstalking were created because the internet, somehow, makes defamation an unviable remedy, he still claims that Houston Wade made defamatory comments about him. Here are the claims at issue. Note: during the testimony, Wade made many more allegations, and Doers made responses to those new allegations. We will not spend any time on those new claims and, Instead, we'll focus solely on the 10 allegations made by Houston Wade on his Bainbridge Island Bad List Facebook page.
On the Bainbridge Island Bad List, the report I wrote was factual and not defamatory, even though Mr. DeWars has threatened a defamation lawsuit repeatedly. When I wrote Mr. DeWars' colleagues and partner, I stated factually what was written in the Bainbridge Island Bad List, and I said the solution is to get Mr. DeWars into rehab, which is true. He needs to stop drinking. Mr. DeWars has perjured himself several times over the course of this proceeding. I'd like to submit his evidence. He claims that he is not a drunk, not an alcoholic, and not a drug addict. This is an email he sent to his wife August 20th, 2014, where he admits to abusing his spouse and blames his alcoholism and chemical dependencies for such. This has not changed. I'm sure that after his domestic violence conviction in 2014, when he had to go to counseling, it may have been the first time in his adult life he had ever been sober.
Tell me what it is that you see as the issue with this post.
He's an abusive alcoholic. No, I'm not. He commits domestic violence. No, I haven't. He's been charged multiple times for obstructing law enforcement. No, I haven't. He claims to represent clients he is not. No, I haven't. He's banned from several local restaurants. No, I'm not. He exhibits drunken, belligerent behavior. No, I haven't and I don't. He spent his marriage trying to have sex with women using internet dating sites like Tinder and seeking arrangements. No, I didn't. John is currently going through a contested divorce where, despite a no-contact order, there's no no-contact order.
Was there ever a no contact order against you?
Never one other than the temporary no-contact order that this court issued in January 2017 that was voluntarily abandoned by my spouse.
Was there any portion of this post that's true?
I pled guilty to hit and run.
That's the only portion of it that's true?
Yes.
All right. But is it true that you have a conviction for imprisonment of a minor and domestic violence?
In 2012.
So yes, is that
Right.
okay? And what about domestic violence conviction?
That's the same thing.
Okay, so yes, that's correct.
Correct.
Okay. And it's correct that you have a conviction for hit and run,
Correct.
but you don't have a conviction for obstructing a public officer.
No.
Okay. But were you ever charged with that?
I don't think so.
Okay.
And Mr. DeWars claimed that he never used seeking arrangements. A young woman named Grace Greco messaged me with proof that Mr. DeWars contacted her to pay for sex via that website. His username is Nice Guy.
I've never used the internet to obtain sex for money, in exchange for money. The post that he showed over there doesn't show anything except that I was on that website after I separated from my wife. And in fact, I was investigating the website for a class action because of the expiration of credits under Washington's gift certificate statute. I had a client that I was exploring that for.
Mr. DeWars also claimed that he was never charged with obstructing a public officer. He was charged and in this court for relating to his hit and run accident with that very charge, and this is also a copy of when he was charged in 2003 for that same thing in Kirkland. This is screenshots of his conversation with Ms. Evans, where he claims he was never tossed from Brusciato and that he is the attorney for Mr. Brendan McGill. And then lied again and said that he was the attorney for Brendan McGill, the owner of Brusciato.
He says I'm banned from multiple locations, including Brusciato. That's not what I was told, and I had a good relationship with Brendan McGill, the owner, for a long time. I've been into San Carlos many times recently. I've never been told that I was unwelcome at San Carlos.
Mr. DeWars did claim in his petition that the information presented is almost entirely false. For example, that he doesn't have criminal convictions, although when pressed, he does admit that he has convictions for domestic violence, hit and run, imprisonment of a minor. He denies being charged with obstructing, but Mr. Wade did present evidence that suggests that he has been at least charged with those offenses in other court. There is also, Mr. Wade also countered much of Mr. Duars's testimony by presenting evidence that shows the basis of his knowledge and why it is that he says what he does. Some of it is lengthy and perhaps not as content very relevant to the concerns, but there are pieces of it that are relevant because it is the reason that Mr. Wade feels compelled to say that Mr. Duars is abusive, that Mr. Duars is a alcoholic, and that he has been in crashes for drunk driving, and that he has been on sites where there has been perhaps negotiations for sex. There was at least one document that was from a woman on Facebook that had a conversation with Mr. Wade where she explained and sent him a post of Mr. Duars' profile on seeking arrangements.
Mr. Duars not surprisingly tried to argue that speech might be unprotected, despite it being true, and he echoed arguments made by the State Attorney General in Rynearson v. Ferguson, the federal case supported by the ACLU of Washington, that is challenging the constitutionality of our state's so-called cyberstalking law. That law is being challenged because it criminalizes speech solely because of its intent. For example, it makes speech made with the intent to embarrass somebody illegal and punishable by up to a year in jail. Rynearson is claiming in federal court that violates the First Amendment.
I'm going to ruin you. It's going to be so much fun. When we do get to the case law that governs all this, Your Honor, those kinds of comments, I'm going to ruin you and it's so much fun, are the exact intent or mens rea that the courts at the federal and state level are looking at to determine whether or not speech has remained pure, protected First Amendment speech, or whether its combination with conduct has elevated it to the proper subject of the anti-harassment and cyberstalking statutes.
Okay, well, I'll ask you later if you can point me to the citation where it tells me that I don't look at the First Amendment if the intent is negative.
Yeah, absolutely.
What's the conduct involved? Can you explain to me what isn't speech? Factually?
Sure.
In your factual scenario.
The dissemination of deliberately embarrassing information, not for the purpose of engaging in social commentary, but for the purpose of, to use the language of the statute, seriously alarming, annoying, harassing, or causing detriment to such a person.
So is it always harassment to disseminate information that's true that could embarrass the person who is the subject of that?
Great question, and that's why these cases are so tricky. The answer is no, it's not always harassment. The court has to find the requisite intent for harassment by conducting a review of the context and evidence that would seem to reveal intent, such as Mr. Wade's communications to me that his desire in all this is to ruin my life and take away my livelihood.
If a writer for the New York Times has a desire to take down people who have gotten away with sexual misconduct for a long period of time and has a personal desire to do that, and it motivates him to do the research and write the article, is it harassment to write an article about somebody that contains true information because he wants to hurt that person?
It depends on the elements in the particular state. The only elements that
I'm just saying if that hypothesis were here, would that, in the state of Washington, would that then be harassment?
That would be a totality of the circumstances analysis that the court would have to conduct if it was going to enforce the Washington anti-harassment or cyberstalking statutes.
All right, I have reviewed the testimony and exhibits in this case and the case law that is relevant here. As I said in the beginning, I have had a chance to very thoroughly go through all of the paperwork, and I spent a great deal, many hours, many days, as a matter of fact, taking a look at all of this. And and going through it with a fine-tooth comb, and I have prepared some written findings that I'm going to read, and I'm going to go through and discuss what the court is finding and the reason for the ruling as best I can. So in this case, this is a request for an unlawful harassment protection order as well as a stalking protection order. The prior judge found that there was enough evidence to issue a temporary order and did so, prohibiting Mr. Wade from publishing on his pages information about Mr. Dewars. Unlawful harassment is defined as a knowing and willful course of conduct directed at a specific person which seriously alarms, annoys, harasses, or is detrimental to such person and which serves no legitimate or lawful purpose. The course of conduct shall be such as which to cause a reasonable person to suffer substantial emotional distress and shall actually cause substantial emotional distress. And the petitioner has to prove this by a preponderance of the evidence. The definitions in the harassment statute are in 10-14-020. It says course of conduct means a pattern of conduct composed of a series of acts over a period of time, however short, evidencing a continuity of purpose. Course of conduct includes, in addition to, but any other form of communication, contact or conduct, the sending of electronic communication, but does not include constitutionally protected free speech. Constitutionally protected activity is not included within the meaning of course of conduct. 2, the government has a compelling interest in preventing harassment and stalking. And then I listed some of the findings of the legislature. Under harassment, it says the legislature finds that serious personal harassment through repeated invasions of a person's privacy by acts and words showing a pattern of harassment designed to coerce, intimidate, or humiliate the victim is increasing. The legislature further finds that prevention of such harassment is an important government objective. This chapter is intended to provide victims with speedy and inexpensive method of obtaining civil anti-harassment protection orders, preventing all further unwanted contact between the victim and the perpetrator. And RCW 792.010, it says stalking is a crime that affects 3.4 million people over the age of 18 each week in the United States. Almost half of those victims experience at least one unwanted contact per week. 29% of stalking victims fear that the stalking will never stop. The prevalence of anxiety, insomnia, social dysfunction, and severe depression is much higher among stalking victims than the general population. There are many cases in the state of Washington that have provided that prohibitions against harassing and stalking behavior do not infringe on First Amendment free speech rights. And I quoted some cases here: State v. Smith, State v. Bradford, State v. Noah, and a federal case, U.S. versus Matusewicz. And particularly in the federal case, it does a good job of explaining that speech that is integral to criminal cyberstalking is not protected. The court finds that the stalking and harassment protection order laws are not unconstitutional as applied to the respondent. The court finds that Lee engaged in a course of conduct directed at Moriwaki, where Lee repeatedly contacted, harassed, stalked, and cyberstalked Moriwaki. The court finds that all of the elements of stalking under RCW 9A46110 and cyberstalking, RCW 961-261B, repeated contacts, and unlawful harassment, RCW 10-14-020, have been proven by a preponderance of the evidence. So the issue here, in looking at the stalking protection order, stalking in the findings in 7292.010, the findings indicate that protection can be accomplished without infringing on constitutionally protected activity. 792.01 requires that any stalking conduct also serves no lawful purpose. And so the issue here really is there a legitimate or lawful purpose for this behavior? I think that Mr. Dewars has established that the respondent intends to cause harm to his career and have him perhaps be punished by the Bar Association or by, his partners and his law firm, and that he intends to provide a public airing of Mr. Dewar's wrongdoing. And I think that's very clear from the information that's in the record that he has a dual intent, both personal and, as he indicated, to protect others from people who he considers to be abusive or harmful to women and children. Lee paid Facebook to advertise the page with Moriwaki's name and image, which then went out to Moriwaki's friends and others that did not seek out the page. The court finds that these acts were done with the intent to harass, embarrass, intimidate, torment, and retaliate after being limited and blocked from Moriwaki's personal Facebook page. The acts were also done to cause damage to Moriwaki's reputation. So, the legitimate or lawful purpose, as referenced by the statute, would include constitutionally protected free speech. And free speech would be a legitimate or lawful purpose. Of course, there are certain narrow, limited classes that are unprotected by free speech, and they are obscenity, defamation, fraud, incitement, true threats, speech integral to criminal conduct. Mr. Dewar's tried to argue that there was proof here that there was incitement or true threats and also speech integral to criminal conduct, and the court finds that there really is not. So I reject the claim that these actions cannot be prohibited under the First Amendment right of free speech. There's an interchange where if you have conduct that, there's speech involved with the conduct that's being carried out, and that conduct has been limited by the state of Washington as harassment and stalking, then you don't get to just say, well, I spoke, therefore I have a free speech right. The state of Washington and the court has a right to limit these actions when they fall into this course of conduct of being harassing, which the court specifically finds they were. I reject the claim that they have a right to attack him as a public figure. He is not an elected official, and in his volunteer role, it has not rendered him a limited purpose public official. That there's nothing about Mr. Wade's publications that indicate that he wants people to try to injure Mr. Dewar's or that to do any sort of illegal acts. The respondent has no criminal history and has not made any threats implying physical violence towards Mr. Moriwaki. Further, this court cannot find any incidents of threats or violence in his past, but just that he wants them to try to stay away from Mr. Dewar's. I considered this very carefully. I want everybody to know that. I really read through every single thing that was filed in this court. And the court certainly finds that Mr. Rynearson is very irresponsible with a lot of his speech and doesn't really care all that much about how he makes people feel or the damage that it causes people through his actions. Additionally, the proof really would lie in Mr. Dewar's in trying to prove that this falls within the defamation category. And if it was indeed defamatory speech, then it would not have that constitutional protection. I don't agree with Mr. Dewar's assessment of the case law that if Mr. Wade had a intent to harm him, then that overrides the constitutional protection of speech. And I don't think that's what the case law said. Petitioner filed an additional newspaper article today that indicated he desired to continue his online criticism. I read many of the cases that were cited by Mr. Dewar's, even though some of them were not published opinions. So the cases that the court finds most instructive in this particular case is State versus Noah. In Noah, the respondent picketed outside on the sidewalk in front of a therapist's office, with signs that indicated voodoo therapy practiced here, Dr. Kaloff, you windbag, psychotherapist, big bucks for therapy, spreading child abuse hysteria, and David Kaloff, voice of hatred and revenge. In that case, Mr. Noah did not even have a connection to this particular therapist. In fact, his daughter was treated by a totally different therapist in the office. But the court found that the picketing behavior could not serve as the basis of an anti-harassment protection order because it involved free speech, which is a lawful purpose. I specifically find that creating a Facebook page or web page that has his name on it is not about discussion, it is about targeting and harassing him. And it indicates that speech on the, or by application, the speech on the internet is our modern day picketing, and that's why the court is going to prevent you from doing that. I also find he's not a public figure and you don't get to use his picture, personal identifying information, and things that you want to create because you have a history of harassing him. So that's the reason for the court's order. And that's what the court found in the Rauge appeal in the Rynearson case, and in fact overruled a prior order of mine indicating that speech on the internet is much like picketing, and it's a public forum where people are able to communicate with one another and post information. U.S. v. Cassidy is also applicable here. That is 814 Federal Supplement 2nd 574 2011. And Cassidy, a former sect member, used Twitter and a blog to comment on the sect and the sect leader. All but a few of the nearly 8,000 Twitter posts by the defendant related to the sect or the sect leader, and the federal court upheld the speech as protected speech and dismissed the indictment for stalking against him. The court in Cassidy reasoned that the First Amendment protects speech even when the subject or manner of expression is uncomfortable and challenges conventional standards of good taste. The U.S. Supreme Court has consistently classified emotionally distressing or outrageous speech as protected, especially when it touches on matters of public concern. And in this case, I would find that there is an intent to air this information because of public concern and trying to be protective and information sharing to people who could be at risk in the author's opinion. Speech cannot be restricted simply because it is upsetting or arouses contempt. The court very bluntly explained in Cassidy, Twitter and blogs are today's equivalent of a bulletin board that one is free to disregard. Here, the speech may be defamatory in nature, however, I don't find that that has been proven. The contents of the posts warn the public about Mr. Dewars and his criminal history, his use of alcohol, and his behavior in the community as an attorney. There are posts on the Facebook pages of Houston Wade and the Bainbridge Island Bad List. There is an email to Mr. Dewars' law firm at info@newmanlaw.com and a review post on Google Business. While this behavior, the court may not, or this way of the public shaming, the court may not agree with from a taste perspective, I think that it is constitutionally protected speech, and the court cannot issue the order that is asked for by Mr. Dewars. The case law indicates that to do so and to prevent him from having any speech related to Mr. Dewars is what is considered a prior restraint on speech, and it's prohibited from the First Amendment, by the First Amendment. And so the court is not able to grant such a request. I think that Mr. Dewars could have presented evidence and perhaps tried to meet his burden by perhaps presenting some criminal history record of his to show that he did not have the charges that Mr. Wade claims he does, or he could have presented affidavits or testimony that show that this is true fabrication. I don't find that the one-on-one conversations are part of the harassment scheme. I think that they often were initiated, or are almost always initiated by Mr. Dewars, and was a back and forth that was really mutual, and that it was not harassment but more of a disagreement. I also think that there is a public concern element in contacting his employer because he talks about criminal behavior in the community, which is admitted. He talks about other behavior that would be of public concern for a person who is an attorney, and follow up with the Bar Association. And to prohibit him from contacting his employer would be, even if the court were to find that there was harassment, will be well beyond the scope of what the court can do. The court cannot prohibit a person from having contact with third parties in the scheme of a harassment order. The court could prohibit the respondent from having contact with Mr. Dewars, but in this particular case, I'm not finding that there's a pattern of conduct where he's reaching out to Mr. Dewars and trying to harass him. I think that there's just a disagreement going on about the behavior of maintaining this board. So, and I would also disagree with some of the characterization of the case law. I have looked at the case, in particular the Beanie case, and I think what's distinct about some of the cases that are cited by Mr. Dewars is that sometimes they're on legal issues that don't relate exactly, but factually they are often cases where there is proof that there was actually defamatory conduct. And in Beanie, specifically in the facts, it talks about the, I'm going to pull the case up. In that case, Mr. Beanie was contacting the past employer alleging that I was a criminal, and he claimed that I was selling homes without a license, falsely representing myself, and not using my real name or going by many different aliases. And in the discussion as well, during the facts, it says Mr. Beanie admitted he had no knowledge whether or not these allegations were true. And that is the crux of what some of these cases are based on, is that there is enough basis to show that this was really reckless in the language that was being shared, and there was no basis of knowledge. And I just can't find that here. I think that at least in the case of Mr. Dewars, Mr. Wade has a reason that he feels that this information is true and not defamatory, and he's sharing it. If there are particular statements that are incorrect, certainly Mr. Dewars has the remedy of seeking a defamation suit, as he has alluded to, and he certainly can appeal the court's order here today within 30 days. But the order of the court is that the request for full order is denied, and the petition is dismissed.
Judge Sara McCulloch did an excellent job not being persuaded by this faulty argument. What is very interesting, however, is that this same argument was made earlier to her by Clarence Moriwaki. It was evident that Rynearson's amicus brief, which he filed in support of Houston Wade during this proceeding, and the arguments from Rynearson's own court pleadings before Judge McCulloch in Moriwaki v. Rynearson, were used this time in her ruling. Judge McCulloch's ruling in this case was 180 degrees from her earlier ruling in Moriwaki v. Rynearson. That case involved a retired military officer posting civil criticism of Moriwaki's partisan use of the Bainbridge Island Japanese-American Exclusion Memorial's platform. Rynearson's opinions were posted on Moriwaki's page as they were Facebook friends. While Moriwaki did not tell Rynearson to stop posting on his Facebook page, as Judge McCulloch wrongly found, Moriwaki did block Rynearson using the ample tools that Facebook provides to users. Despite the inaccurate finding of Judge McCulloch, Rynearson made only one attempt to contact Moriwaki through a single text message conversation initiated to ask Moriwaki if he wanted to comment for an article. As soon as Moriwaki told Rynearson to stop contacting him, Rynearson ceased any and all contact with him. Rynearson then created a Facebook page to share his criticism with the community, and he also posted it on personal Facebook pages and groups. It was well received in the Bainbridge Island Open Community Group, but Houston Wade, a moderator in that group, then banned Rynearson from the group because Rynearson had criticized his friend. Rynearson's posts were not defamatory and included no obscenity or profanity. Judge McCulloch found in Moriwaki v. Rynearson that Rynearson had no prior convictions, no criminal history, and had made no threats to anybody, ever. She also did not find that Rynearson's speech was untrue, and she did not find that Rynearson had contacted Moriwaki's professional peers, nor that Rynearson asked anybody to stay away from Moriwaki. Still, in that protection order hearing, Judge McCulloch not only censored what Rynearson could say online, but she also permanently restrained Rynearson from using his own purchased property, as she deemed his property to be too close to the condo rented by Moriwaki. She also prevented Rynearson from attending any public event that Moriwaki would be at, such as the 4th of July parade or the Turkey Trot or any other event that Moriwaki might attend. She did all of this while not being persuaded by the legal authority Rynearson provided to her in his court filings, despite using that same authority correctly to find for Houston Wade. Now we turn to theories on why Judge Sara McCulloch issued an opinion that was so blatantly incorrect on the law in the case of Moriwaki v. Rynearson, to then turn around to 16 months later and issue a completely opposite ruling using the very law that Rynearson had supplied her. There are two possibilities as we see it. The first possibility is that Judge Sara McCulloch was completely incompetent and could not understand the law just over a year ago, but after her ruling in Moriwaki v. Rynearson was overturned, and after Rynearson filed a federal lawsuit supported by the ACLU of Washington, Judge McCulloch finally went over the law with her so-called fine-tooth comb, and only then came to the conclusion that people have a right to criticize others online to the public. The second possibility is that Judge Sara McCulloch is corrupt, and she applies the law faithfully when it suits her, or her friends, and yet fails to apply the law faithfully when the law contradicts her personal interests. For the first theory to be true, Judge Sara McCulloch would have to be beyond incompetent as a judge. The free speech issues in both of these protection order cases are not complicated, and even lay people, without a legal education, commonly understand that they have a right to criticize a person, to their friends, or to criticize a person to the public, so long as what they say is not false, or truly threatening, or attempting to get another to commit murder, or some other actual crime. For a member of the legal profession to not understand this basic legal landscape, however, is a more difficult task. It's made even more difficult when a judge has the opportunity to read well-written and persuasive legal briefs that make the law crystal clear. So clear, in fact, that said judge would make the same arguments later in a new hearing as she did in this one. As one commenter on a Washington Post article stated about Judge McCulloch's protection order, it's a hard pill to swallow the idea that this judge simply did not know the law. Or, as another commenter in the Washington Post article commented, some things should be obvious to even the most minimally educated. We have to agree, a lack of understanding of the law is a very hard pill to swallow in this instance. So we now turn to the second theory. The second theory is that Judge Sara McCulloch is corrupt and only applies the law when it suits her, and ignores the law when it doesn't. It is possible that she saw ruling against Clarence Moriwaki, a long-time resident of our island, a very politically connected man who personally knows and worked for Governor James Lee, as a bad idea for her political future in our state's judiciary. It is possible she then chose to give Moriwaki the protection order he sought, despite the fact that Moriwaki's claims were ridiculous, and despite the fact that Moriwaki blatantly lied to her in court about evidence he told her was a violation of the protection order that he had just picked up that morning. All of this is possibly explained as done because she did not know Rynearson, who had just moved to the island, but that she did know of Moriwaki and his political influence. It is possible, too, that she knows that Houston Wade is one of Moriwaki's friends. A friend who not only kicked Rynearson out of a Facebook group for criticizing Moriwaki, but also vocally supported Moriwaki in her courtroom against Rynearson. Judge McCulloch is no doubt aware that Houston Wade sent her emails to warn her about comments that Wade alleged, without evidence, were made by Rynearson, comments that were critical of Judge McCulloch's performance in Moriwaki v. Rynearson. And Judge McCulloch was certainly made aware that Clarence Moriwaki was in the courtroom during Wade's protection order hearing.
All right. And did you indicated earlier that you were going to have Mr. Moriwaki testify?
I just had Mr. Moriwaki here as a friend, emotional support, to sit with me. I never had intention to call him as a witness. I wasn't sure if Mr. DeWars was going to.
Okay, I guess I misunderstood that you were earlier in the hearing. Is Mr. Moriwaki still here?
Yes, he's still in the hallway, yes, Your Honor.
All right, well, then he can come in. I did not understand that he was not a witness.
We may never know which of these two theories is correct, but we know that one of them is true, and neither are acceptable for members of our judiciary. Still, we may gain a better understanding of which is most likely true on December the 3rd, when Houston Wade faces his next protection order hearing, brought by Bill Nelson. Judge Carruthers found that at least one allegation made by Houston Wade against Bill Nelson was defamatory and untrue with evidence to back up its falsity. We suspect that Nelson is not going to waste time arguing Moriwaki's failing argument, as Duers did, but will instead concentrate on unprotected defamatory speech given his testimony at the Duers protection order hearing.
Did Mr. Wade make grave allegations against you in those posts?
He made extensive allegations against me that were all untrue.
What allegations did he make that were untrue?
Rape of a woman, abusing my stepchildren that evidently he felt he had knowledge of, which beyond me how he would ever have attained that, because I've never abused anyone, my children. He accused me of abusing my ex-wives. He accused me of being married 5 to 7 times. He accused me of abusing and taking advantage of my partners. He accused me of bringing outside money in from out of state for my campaign. I mean, it goes on and on and on. All untrue, unfactual, and unsubstantiated. He has no facts to the matter. He is someone that was involved with the chicken coop, involved with deplorable examples of taking advantage of either underage or young women. He also accused the police department of this. He also accused the fire department of this. So everybody's included in Mr. Wade's fantasy world.
All right, Mr. Wade, would you like to ask any questions?
I would, thank you. We've known each other since I was 4 years old, when you married my best friend's mother. So to say that you only met me in 2001...
Is there a question? You're asking questions. You're going to get a chance to provide testimony.
So yes, in 2001, when we ran for city council, and later I was out in the primary, you went on to general election. Did you ever come into Town and Country and threaten my life?
No.
Did you ever do so in front of 30 witnesses?
No.
Did you ever come in repeatedly over a course of 5 nights and threaten my life?
No.
Did Town and Country have to obtain a security guard to guard me at night because you'd come in and try to kill me?
You're fantasizing. No.
Excellent. Did you ever grope Ashley Cross?
No.
Did you do so in front of her father?
No.
Did you ever get charged with drunk driving?
I have.
Recently?
I have.
Are you an alcoholic?
That's to be decided by the treatment program that I'm in.
Okay.
Your Honor, I'm going to object on relevance grounds to the DUI. None of those are part of the posts. I don't think there's any mention...
The posts I refer to him as an alcoholic, Your Honor.
If so, then I think it's reasonable.
Have you ever used cocaine?
Years ago.
Have you ever used it recently?
No.
When was the last time you used cocaine?
In my 20s?
Really? So you were 20 years old in 1999?
I'm sorry?
Were you 20 years old in 1999?
Do you have something you're trying to drive to here?
Yes, because I witnessed you using cocaine when you showed up to a high school party March of 1999 and then forced yourself on a 15-year-old girl.
You're going to have to substantiate that through background information.
I will. Sorry, Your Honor.
Any other questions?
No, we'll probably discuss the rest of this next week at his...
To conclude, Judge Sara McCulloch ruled correctly on the law in this hearing. But we are not sure if she did so because she is incompetent, and it simply took her this long to figure out the First Amendment, or if she is corrupt. We will be eagerly awaiting the decision of the court in Houston Wade's next hearing. Thank you, neighbors, for staying informed about the state of our civil rights and liberties on our island. Together, we can make our island constitutional again, and we look forward to working with our neighbors more in the future. Please drop us a line at the email or on our Twitter page with any comments or scoops, and, as always, ciao for now.